once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. I want to begin by welcoming all of our viewers who are joining us on television from Region Number 5, West Coast, Berbice. Welcome to another program of Issues in the News. To all of our viewers who are joining us on television from Region 6 across the Berbice River, along the east bank of the Berbice River, New Amsterdam, Kanji, and right along the Quarantine coast, up the Quarantine River, to Oriala and Siparuta, welcome to another program of Issues in the News. To our friends who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, the Middle East, and as far away as Australia. Welcome to another program of Issues in the News. Share the live on your page, on your profile, so that all your friends and your followers can join us in tonight's discussion. Press the share button on your phone, on your computer, share it on your tablet, share it on your iPad, so that all your friends and followers can join us in tonight's discussion. And also use the comment section to express your views, to ask questions, and to generally invite me to discuss any issues that you may wish us to discuss. I want you to engage. I want us to engage. I want the program to be an engaging one. So use the column section and make the program interactive and engaging. So having gotten those preliminary matters out of the way, I see Anil Jairam, Rajin Datadin, Ramona Beer Karim, Rihanna Lux, Matbar Singh, Hari Gill, Hare Sankar, and so many of you who are already on the live. Welcome to another program of Issues in the News. And I want to begin by informing you that tomorrow morning a number of Court of Appeal judges will be appointed by His Excellency the President, Dr. Mohammed Irfan Ali, at the office of the President. You may recall that recently we made amendments to our Court of Appeal Act to increase the complement of judges to sit in that court. I explained that while we have, in the main, successfully addressed the backlog of cases that had accumulated for decades in the High Court, the backlog seemed to have now moved to the Court of Appeal, because we had very few judges in that court to begin with, and then there were vacancy. So we had increased the complement from a total of, I think, 5 to 9, and then recently we increased it from 9 to 11. So we should have, at any given time, a Court of Appeal that can sit in 3 different quorums. The Court of Appeal normally sit in numbers of 3, and when the court is sitting, the complement of judges at that sitting is called the quorum. So we can, so you have 3 trees or 9, and you still have um, two judges to make 11. So you can have 3 quorum now, and you still have 2 judges extra. One may be on leave, or one judge may have to sit in chambers. So there is enough flexibility in the complement of judges for there to be many sittings of the court. And as I advocated, the court can now become an itinerant court of appeal. That is to say, it can now sit in all 3 counties at the same time. So you can have 3 judges sitting in the Berbice High Court as the Court of Appeal, and you can have 3 judges sitting in Essequibo, in the Essequibo High Court as the Court of Appeal. It matters not where they sit, once they are able to do the work. And if we are to sit that way, then, I believe that there would be a reduction in the backlog of cases that are pending. Also, you can have many different courts, different sittings of the court at the same time, because we have now an extended building. The building that was there before accommodated only 1 court, so you could only have had 1 court sitting at a time. Now you can have more than 1 courts sitting at a time at the seat of the Guyana Court of Appeal at Kingston, Georgetown. So that's the first important issue that I want to address. But tonight I want to deal specifically and hopefully comprehensively with one issue, that is the Oil Pollution Prevention, Preparedness, Response and Responsibility Bill of 2025, which we passed in the National Assembly last Friday. And from Friday to now, we have been bombarded in the mainstream media in the main with a deluge of misinformation, distortion, misrepresentation, misunderstanding, and incoherence in relation to this bill. And I want to address some of those public outpourings tonight, simply to assist in clarifying this important matter for the public. Those who are peddling this avalanche of misinformation and, as I said in the Parliament, unadulterated ignorance, may have their own agenda. Certainly it is not an agenda that coincides with the public interest. It is not an agenda that advances the public good. In my view, it is an agenda of a sinister type, and it is an agenda to put those who are peddling these views on the front pages of the newspaper and to give them wide coverage in a willing press environment, because you have the press entertaining this type of publication. I say so because Kaichor News has had an almost obscene obsession of an inexplicable nature with the oil and gas industry. And anyone who says something critical of the industry finds him or herself very easily on the front page of the Kaichur for days at a time. So if you want free publicity, whoever you are, whether you are qualified to speak on the matter or not, whether you are somebody of substance or not, whether you live in Guyana or live outside of Guyana, once you say something that is critical of the oil and gas sector in Guyana, you are guaranteed the highest degree of prominence in the Kaichor News, not on a singular day, but in a series of publications. So you have that forum readily available to publish anything, and I say anything, critical about the oil and gas sector. There is no care whatsoever to ensure whether what is said has any authenticity in truth, in law, in science, in geography, or in any given sector. It matters not. There is no care to confirm, verify, corroborate, or test the veracity of what is being said. No care, no effort whatsoever. Whatever is said is published unconditionally, regardless of its accuracy, regardless of its validity, regardless of its authenticity. And that's the policy of Kaichor News. Then there is an added element to that. Any criticism of the government in this sector also guarantees you equal prominence in the publication. So, if you look at the coverage of the debate in the National Assembly by the Kaichor News in relation to this bill, you would see the lead story came from the speech, or the story itself. The lead part of the story came from the speech of Sherwin Holder, followed by the speech of David Patterson, followed by the speech of the Prime Minister of the country who tabled the bill, followed by the Attorney General who spoke elaborately on the bill, and then Minister Indar. In that order. It is the government's bill. The Prime Minister of the country is the lead speaker on the bill. He opens and closes the debate, but Kaichor News gives him third in coverage, with Sherwin Holder, who, by the way, was inebriated in his presentation. And I've since asked jocularly, I've said that they should introduce a breathalyzer test in the Parliament now. Sherwin Holder, he was given lead coverage as the lead speaker in the Kaichor News coverage of the debates. And then Patterson got second in terms of priority. Then the Prime Minister came third. So even in the presentation of the coverage, you get the bias of that newspaper established. Fortunately, more and more people are refusing to read the Kaichor News. So the Kaichor News is on its own path is on its own path, and you can complete the sentence for me. The Stabroek News on this matter is not much different. The bias seems to be the same. The bias seems to be the same. The Stabroek News ran an entire article. They ran an entire editorial, I believe it was yesterday, on the bill. And tried as they did, they couldn't find a meritorious flaw in the bill. Of course, they recited the arguments of Sherwin Holder and Christopher Ram, both of whom I'll deal with later. But as struggled as they did, and as tried as they did, they couldn't find an argument of great substance critical of the bill. So they ended up criticizing the government for taking too long to bring the bill. So that was the wrong committed, which the government was lambasted for. We took too long to bring the bill. We brought, for the press, I did a reckoning of the number of bills we have passed so far. So far in this parliament, with COVID and all the other challenges, we have passed 105 pieces of legislation for the 12th parliament, and we are not yet finished. 105 pieces of legislation. 105 pieces of legislation. Yet Stabroek News, in an editorial, said we took a very long time to pass this bill. They could have easily said, or if they wanted to balance their commentary, tell us which bill in relation to the oil and gas sector did the APNU AFC pass or legitimately pass. They passed a petroleum bill after they were defeated by a no confidence motion. One night they went into the parliament without the knowledge of the public, without the knowledge of the opposition. They themselves slithered into parliament one dark night and passed a bill. Could you imagine that taking place in today's world? So that was a nullity in my view, and we properly repealed it. It was not a petroleum bill, it was the Natural Resource Fund Act. They passed that in January 2019 when they were defeated by a no confidence motion in December 2018. They went back into the parliament illegally and passed that law, and we repealed it. They didn't pass any other bill in relation to the oil and gas sector. And they were there from 2015. Since they got in, they knew that oil was going to be produced, because we announced that before the 2015 elections. And of course they signed the 2016 infamous lopsided profit sharing agreement with the licensees. And they gave the first set of license. They never passed one single piece of regulation, not even a subsidiary legislation. No legislation whatsoever. We got into government 5 months after we won the elections. We got into government and began to sit in parliament of September of 2020, whereas we should have been sitting in parliament since March of 2020. And we were able to pass the Local Content Act, the Natural Resources Fund Act, the Petroleum Activities Act, and now the Oil Pollution Prevention, Preparedness, Response and Responsibility Bill. And then we were also able to draft a model PSA that will govern PSAs in the future. Complicated document that took a few years to draft. Each of the legislation that I'm referring to, each of these statutes are landmark in their own right. They are all technical and complex pieces of legislation. We consulted widely on all of them, internationally and nationally. Public consultation and consultation with important stakeholder organizations. And in 4 years, we were able to pass 4 major pieces of legislation in the oil and gas sector. 105 across the board for the period thus far, from September 2020 to now. Stabrook News editorial criticizes us for passing the bill too late. If you do, you're damned. If you don't, you're damned. You can't win these people. But we have to continue to do what we have to do. So this bill, as all the others, this bill was drafted by experts in the United States of America and sent to us. It complies with all international standards and international treaties and international laws relevant to the sector. In drafting this bill, the consultant looked at legislation in a number of different territories and in a number of states within territories that have federal governments and provincial governments. So we looked at legislation in the United States and in several states in the United States, in Canada and several provinces in Canada, the United Kingdom, Australia, Norway, Ireland, and some other territory I can't remember. I had it in my speech in the Parliament. I listed all the territories. The bill meets all international standards and requirements. After we received this bill, it spent nearly a year in Guyana going through a process of adaptation to bring it in conformity with and inconsistent with our local circumstances. And then we had to consult with all the agencies and stakeholders touching and concerning the bill, or which the bill touched and concerned. So you had the sector itself, with whom we consulted, then the various agencies that have to play an important role in the bill. The Environmental Protection Agency, the Civil Aviation Authority, the Guyana Energy Agency, the MARAD, Foreign Affairs, and some other agencies within the state sector. I think the private sector was also consulted. And I have some notes here. on what I want to say about the bill, in terms of what the bill is, because there is a strenuous effort out there to publicly distort what this bill says. This bill is deliberate and necessary evolution of Guyana's legislative framework intended to bring our petroleum sector into closer alignment with international best practices. It ensures environmental safeguards, and it creates legal clarity around liability in the event of oil pollution. Those are the main pillars upon which the bill is constructed. And there are some provisions in particular that have excited discussions. First of all, you have persons like Miss Melinda Janki, who has written a long, exhausting and exhaustive epistle to His Excellency the President, in which she ranted and rambled for an inordinate period of time. And I'm being very respectful. I want to put on the public record that, and she relies on the Environmental Protection Act. She cites that as one of the bases upon which she criticizes this bill. She says this bill whittles down that act, and then she says that this bill whittles down the constitutional protection which is accorded to the environment. Well, I want to make it very clear to the public that the Environmental Protection Act that Miss Janki is hailing and is acclaiming is an act passed by the People's Progressive Party government since 1996. Over nearly 3 decades ago. Nearly 3 decades ago, 1996, we passed that. And today that act stands out as an act that was way ahead of its time, and up to now, is our main guiding legislation on environmental protection. That act speaks about assurance and insurance long before we ever heard about Janki. Long before Janki accumulated environmental credentials, and long before she became an environmental protagonist, the People's Progressive Party Civic had enacted that piece of legislation that she is now embracing. That's the first point I want to make. All the provisions that she's relying on in the Constitution, Article 35 and Article 35 is one, I think. Then you have Article 49J that speaks to environment, that the environment is a fundamental right and freedom. The right to a safe and clean environment is a fundamental right. Go and check it, Article 149J. Were put into the Constitution by the People's Progressive Party Civic Administration in 2001. The Section 35, the Article 35 that she's relying on, was put there by the PPP government in 1999-2001, that period when we did the constitutional amendments. the point I am making is that long before the Yankees of Guyana came on the scene, long before any one of you ever heard about a person named Melinda Janki, these things were put in the statute books of our country and in the constitution of our country by the People's Progressive Civic Government. We laid the foundation for environmental protection in this country. We are the authors of the low carbon development strategy. We are the main architects behind a market to sell carbon credit. It is the PPP's government through Bharat Jagdev and others, Janet Jagan, Chedi Jagan, all of this came out of the People's Progressive Party civic government long before Janki ever came on the scene. And today, persons of the ilk of Ms. Janki criticizing the People's Progressive Party civic government, holding up what we have put in the law and using it to attack us. Ms. Janki can go and check the constitutions of other Caribbean territories and other Commonwealth territories. And I challenge her to find like provisions dealing with the environment as they are in the Guyana Constitution. In her next letter to the public, she must find which countries in the Caribbean or even the wider Commonwealth that embraces environment as a right, safe environment as a right, clean environment as a right, and as a fundamental freedom, the way that the Guyana Constitution does it. And these people want to criticize us using our own instruments. These things were never in constitutions before. So I want to make that fundamental point before I move on. So there is the bill has 39 sections. Under the broad head, it sets up the infrastructure that will administer the bill. Then it deals with pollution prevention and emergency preparedness. It speaks to the requirement of a national oil spill contingency plan and what each operator in the sector is required to do. Then it has the oil spill response and how it is coordinated and how the public is notified. Then it has environmental restoration, how you restore the environment. Then it deals with liability. That is, and I'm going to go through all of them for you. And then how persons can make claims if they have suffered losses. And then you have financial responsibility. And then you have a penal section with a list of offenses. So let me get straight into it before we run out of time, because I don't want us to run out of time here. First of all, please look at my speech in the Parliament, because I can't repeat what I've said there. So this is a continuation of that, because I need to narrow my response here to what is being said in the public domain. So, liability. So let me start with environmental restoration. This is what the bill says. where oil spill removal operations are complete. Section 16 or clause 16. Where oil spill removal operations are complete, the Environmental Protection Agency shall direct a responsible party to implement the necessary actions to restore the natural environment, and the responsible party shall comply with the environmental protection when such actions are required. So the responsible party, and let us see who is the responsible party that is defined. The responsible party means, in the case of a vessel, any person owning or operating the vessel. B, in the case of an offshore facility, operator of the facility or the holder of an exploration, a production or a pipeline license under the Petroleum Activities Act, or C, the holder of a license for deepwater port. In the case of onshore facilities, the operator or licensee of the facility or pipeline, or E, in the case of an abandoned or decommissioned facility or vessel, the party who have been responsible immediately prior to the abandonment or decommissioning of the vessel or facility. So any person, if you're operating a vessel, if you're operating a facility, if you're operating onshore, offshore, or even after you left, after you leave, after you shut down your operation, if there is any type of oil spill coming back for you, do you want a wider coverage than that? Tell me, how can you get wider than this? And this is what they find defective. So let us go to the other parts that have excited great sensation in the press. That is clause 16. So you see the environment, you see the widest possible meaning has been given to the term responsible party. Then you see that the environmental agency has the power to direct a restoration, a complete restoration of the environment after the oil spill is cleaned up. And the responsible party got to fix that. Let's go to 7 now, under the caption liability, Article 17 or Clause 17. A responsible party is liable for all damages caused by an oil spill incident. Let me read that again. A responsible party is liable for all damages caused by an oil spill incident, removal and removal costs, and restoration of the environment as far as practicable, and for any costs arising therefrom or connected therewith. Where is there a limitation of liability in this clear English language that I'm reading here? And that is why I am saying to you that these people do not have the public interest at heart. They're not advancing the public good. It's either that or they're tremendously ignorant. I don't know. You have to pick. Because I'm reading here to you. And go and read the bill for yourself. This section here has caused quite a stir. And listen to it again. A responsible party is liable for all the damages, not some, all the damages caused by an oil spill incident, the removal and removal costs, the removal of the oil spill and the oil, and the removal costs, or the costs associated with that removal, and restoration of the environment, as far as practicable. So as far as it is practicable, you got to restore the environment. And for any other costs arising therefrom or connected therewith. My friends, I don't know. I point to a better drafted provision than this. But you hear Sharwayne Holder and Christopher Ram and Janki finding fault with this. This does not limit liability at all. And you don't think that the licensees wanted a cap on liability? We said no. Wherever the damage flows, liability will run. Liability runs with the damage, or the damage is caused. No cap on liability. None. That is what we have here. 18. 18. Removal costs referred to in section 17, that's the removal costs in section 17, shall include all removal costs for any removal action taken in accordance with the National Contingency Plan by any person or state or any agency of state. So anyone who helps in removal or who participates in any removal action, they are to be compensated. Any party, including the state. 19. Liability for damages under section 17. Section 17 establishes the liability, all damages. We didn't leave it there. We now going to specify now what and what damages include. They are all listed in section 19. Liability for damages under section 17 includes damages resulting from and include A. Damages to real or personal property and economic losses resulting therefrom. So if your property is lost, your real or immovable, movable or immovable property, and any economic loss suffered thereby, if your property is an income earning or a revenue earning property, the money that you would have lost is called economic loss. You get that too. So if your car was being rented, or car being used for hire, or your building was rented and is now damaged, you're getting not only cost of the damage, you're getting your economic loss. You understand what that means? Your loss of revenue and income. B, loss of taxes. So if you are the state, any losses of taxes, you're getting compensation for it. Loss of taxes, royalties, rents, fees or profits. Loss of profits or impairment of earning capacity due to the injury, destruction or loss of real or personal property or natural resources. All of that you're getting compensation for. Impairment of earning capacity, your personal property, your natural resources, if you're a country, your taxes, your royalty, your rents, your fees, your profit shares. All of that you're getting. It doesn't end there. C, loss or damage caused by preventive measures. Even the loss of or damage that you suffered when you take preventive measures, you're getting compensation for that. And damage related to impairment of the environment. And all damage in relation to impairment of the environment, you're getting that as compensation. What else do you want the bill to say? What else do you want this bill to say? And that is why sometimes I get angry. Because I believe that these people know better, or they ought to know better. Then the other clause that has excited great sensation and great controversy is clause 21. Well, this is the most vulgar and violent misinterpretation of the English language that I have witnessed recently. The most vulgar and violent interpretation of the English language has been done to section 21. Let me read that for you quickly. An indemnification or any like agreement an indemnification or any like agreement, meaning any indemnification or any agreement of that type, shall be invalid for the purpose of transferring liability of a responsible party under this act. You know, these people have interpreted this to say that we are insulating the parent company from liability. This thing says an indemnification or any like agreement shall be invalid for the purpose of transferring the liability of a responsible party under this act. Well, you have to know no law or very little law to put such an interpretation on this section. Lawyers know that companies like to alienate liability. They like to alienate liability. They like to insulate themselves from liability. So a company can enter into an agreement quietly with some other company through which that company transfers all its liability to this other company. So when this company is sued, this company raises up this agreement and says, look, I am not liable, I transfer all my liability to this gentleman here. And when you turn out to find out who this gentleman is, he bankrupt, or he is a shell company. This mechanism here is intended to stop that from happening. These alleged learned persons puts the opposite interpretation to this. This holds the licensees out there to the liability. Oh my. It holds Exxon to the liability. They can't transfer it to anyone else. They can't transfer it to a shell company or to any other company. The liability is kept with them. And then when you look at the fact that they have to give an insurance and an assurance, and then there is a parent company guarantee, then you see the liability runs from the licensees here straight up to the parent company. We deliberately kept it that way to keep the licensee from divesting liability to any third party. And then the parent company guarantee for each one of the co-venturers out there, Exxon, Sinach, and Hess, each of their parent company now are bound by the parent company guarantee for the purpose of liability. This section keeps that pyramid in place, and it is being interpreted as breaking up that relationship and permitting insulating the parent company from liability. A complete and most uneducated interpretation. So let me go on to deal with financial responsibility now, because I'm running out of time. Financial responsibility is dealt with in 4 sections. First of all, we were told by these public commentators that we have repealed the Environmental Protection Act. Some said that we have whittled down the act. Now, what it says is that a responsible party, Section 27, shall maintain and provide evidence of financial assurance to the satisfaction of the competent authority, meaning the Civil Aviation Authority. The financial assurance shall be in accordance with the Petroleum Activities Act and the Environmental Protection Act. The Environmental Protection Act says, and the Environmental Activities Act, they both mandate the operators, whoever they are, to provide insurance and assurance adequate to cover the risk involved. That, and there is no limit. If you go and you look at all the other legislation in the world, there's a cap. They want insurance up to 40 million, 30 million, whatever the sum is. We say we don't put a cap, but it cannot be unlimited, because as I keep saying, an unlimited coverage doesn't exist. But you look at the risks, you assess the risk, and the insurance must be adequate to cover the risk. That is what the Environmental Protection Act says at section 31. And read the act. All these things are online. Financial assurance has the same meaning under the Environmental Protection Act. We are expressly making reference to the Environmental Protection Act. And so one of Janki wrote, I believe, that we repeal the act. The financial assurance under subsection 1 shall ensure comprehensive coverage as far as possible. You must ensure the financial assurance requirement under the section shall ensure comprehensive coverage as possible. This is the highest form of insurance, comprehensive as possible. And as I said, the EPA outlines the risks, outlines how you assess the risks to get the value of the insurance. But it can't be unlimited. And all of this, remember, there's a parent guarantee that caps it off. And let me explain what a guarantee is. A guarantee is if the primary person or the primary operator can't pay the compensation, then you go to the guarantor. And here the guarantor is a parent company. And you have insurance policies, etc. There is no other mechanism known to the modern world for the insurance of these risks. Let me see what else I can deal with, because I'm running out of time. Then clause 28 says a person may claim directly against a surety. You can go directly to the surety where the responsible party, that's the primary party who's here, and who has been found liable to pay the claim, has failed or refused to do so. Or if the responsible party filed a petition for bankruptcy or has become insolvent. So where the person, let us say Exxon locally, refuses to pay their claim once they are found liable, then you go to the surety, you go to the parent company, you go to the insurance company. Or if they file bankruptcy, then you go to the insurance company, you go to the surety, you go to the parent company. Wayne Holder says that they could declare bankruptcy and run away, and that's the end of the matter. That is a level of ignorance that you have to deal with. And these things are expressly in the law. Now, I want you also to look I can't get to complete everything that I want to say, but I want you to also go and look at the environmental permit. If you go on the website, the EPA website has all the permits. And you have 3 pages. I have asked my personal assistant to send it out to the press. 3 pages, no, 1, 2, 3, 4, 5 pages dealing with financial assurance and liability for pollution damages. It has all these things are set out here, pages upon pages of how damages are to be paid if there is any pollution of any type, and how the operators here have to insure against that damage and assure against that damage, and the role that the parent company also must play in ensuring that these damages are adequately covered if they occur. So this whole idea that this is this bill is some mechanism that shields any grouping from liability is a complete and utter misconception. It's deceptive and wickedly so. Because if you have not read the bill, you should not speak on it. And if you read the bill and you can read, and you say what you are saying, well, then you are deceptive. Well, if you read and you can't understand what you read, well, then I have to blame those who you are listening to and who are publishing your views. Anyone listening to me here tonight can go and read the act for him or herself. It's online. It's on the Parliament website. It's on the official Gazette website. You can go and read the permit and the conditions of the permit. The environmental permit. All these things that I'm speaking about are listed in the permits too. Then you can go and read the Environmental Act, Section 31, that speaks to assurance and financial responsibility. And then you can read, all these things are online. Read it yourself, and then you would understand the depth that these characters are going to mislead people. And you have to ask yourself, why? Why? I'm not usually critical of persons, especially professional people. But here, I can't be, when I hear what they are saying and I read what they are writing, I can't believe that these are educated people. And why are they misleading? Why are they setting out to mislead to such an extent? These are not ordinary misinterpretations. These are not ordinary, these are not ambiguous matters that are being misinterpreted. These things are not capable of 2 interpretations, so it's reasonable for one to come to one conclusion. These guys are fabricating things that are not in the legislation, or they are completely and utterly misinterpreting clear English language. Read it for yourself and you will see what I'm speaking about. My operator is signaling to me that I have come to program time now. It's now past 8 p.m. I want to thank you very much for being with me over the past hour. I wanted to cover some more ground, but I think that I have done, hopefully I've done enough tonight to clear up a lot of the misconceptions that have been peddled out there by the Jankees and the Rams and the holders of Guyana. I may have to come back at it at some other time, but these guys will not sit down with you and debate you publicly, because I'm prepared to do that. They will not sit down and debate sensibly and show you, let us go on the television and put on the screen word for word and let them tell you how they are arriving at the interpretation they have arrived at in relation to those words. They would never do that. Because I would like to do that. I myself would like to understand how their mental processes work. But for now, read the bill, please, and you come to your own conclusions. Until we meet again, please enjoy the rest of this evening, enjoy the rest of the week, and may God continue to bless you and protect you until we meet again. Thank you very much.